Hello. Hello, hello. Okay, good. Thank you. Hello, Saket. Can you hear me?
I can hear you. Yes.
Okay, good.
I'll just be back. Yeah.
Yeah.
Hello. Hope you're doing well. Pragya is muted. Hi, Gautam.
Hi, hi, hi.
Hello.
So we're just waiting. I think Ambaz is going to come soon and then we can start off. Yeah, just give me 2 minutes. So I think everyone is here. I think we can start off now. A very good morning, ladies and gentlemen. On behalf of the Embassy of India, Berlin, I welcome you all to today's panel discussion on the occasion of Constitution Day. The Constitution Day is a tribute to a landmark event in our history of modern India when we adopted our Charter of Modernity, that is our Constitution. And today is also an occasion to appreciate the contribution of our founding fathers in the making of this Constitution. And they have ensured that even after more than 70 years after its adoption, it remains as relevant as ever. So the theme of today's discussion is going to be the Constitution of India and German Basic Law, Convergence and Continuing Evolution. We have an eminent panel of legal experts joining us today, and I look forward to some very interesting discussions going forward as we delve into our founding moment and all the events surrounding it. I would now like to invite the Ambassador of India, Sri Parvatineni Harish, to make his remarks.
Thank you very much, colleagues. I welcome you all. It gives me a great pleasure to have you all here today as we commemorate 72 years of the adoption of our nation's founding document. When our Constitution was enacted this day in 1949, I think it was a great beginning for a young nation. On this day, we honor all the amazing men and women who persevered and led a determined effort to give a constitution that all of us, all citizens of India, can be proud of. The Constitution is a living document that evolves according to the changing times. And as a renowned scholar, Granville Austin, said, it conveys the will of the many rather than the needs of a few. I think our close and very friendly relations that we enjoy with Germany draw their strength from the shared values that both our nations and peoples enjoy. These include democracy, freedom, and the rule of law, which are enshrined in our constitutions. I'm confident that this synergy provides a good foundation to intensify our bilateral relationship and partnership and take it to greater heights. Our constitutional systems, both in India and Germany, seem to be very different. However, there are many similarities and also a lot of similarity in the way they have evolved over the years. We can say that though both India and Germany are very diverse societies and have a federal setup, there are so many similarities in our constitutions and the way they have evolved. That it provides a good basis for the discussion by this eminent panel today. The basic law and the constitution have been promulgated within a span of a year in 49 and 50. They established federal parliamentary democracies and both of our founding fathers looked at it more than just as documents. They looked at it as living documents which reflect the will of the people and the changing times. They also looked at the constitutions as transformative documents, bringing about a transformation in politics and society. Like several other constitutions that emerged in the 20th century, these reflect the post-war and the post-colonial periods in Asia, Africa, and around the world. I think they also reflect strong federal structures in India and in Germany. India, of course, has 28 states and 8 union territories, and Germany has 16 Bundesländer. And they have a very important role to play in our constitutional framework. Both of our constitutions lay a significant emphasis on fundamental rights and fundamental duties, which also clearly specify a separation. Though we are completely adhering to the principle of secularism, they also specifically do not prescribe or inscribe a separation of the state from religion. In India, we call it dharma nirapeksh or pantha nirapeksh, which means that the state is equidistant from all religions rather than a strict separation of state and religion. I think more than in any other case, the basic structure doctrine that has come about in India in the landmark case of Kesavananda Bharati versus State of Kerala brings about similarities between our two constitutions. And I think the jurisprudence around the basic structure doctrine I have been given to understand can be traced back to contributions of German scholars in this regard. So despite all the differences between our two countries, we can see that there are a lot of similarities. And I believe that today's discussions by this eminent panel can bring about a greater understanding of what our convergences and similarities are, and what is it that we can look forward to as our vibrant democracies move ahead with the energies of our citizens. Dr. Ambedkar, who's led the drafting committee, said that the Constitution is not a lawyer's document. I'm aware most of you are lawyers and probably many of those who have joined us, but constitutions also reflect the will of our citizens and our people. And it's a vehicle of life, and its spirit is always the spirit of the age, as Dr. Ambedkar said. So once again, I want to thank you for participating in today's discussion. And on behalf of the embassy, I want to thank all the other participants who have joined us online in this discussion. Thank you very much. And I look forward to a very productive discussion today. Thank you.
Thank you, sir. So now we move on to our panel discussion. And before we begin, I think I should let the audience know what it's going to be like. And before I introduce the participants, we're going to give each panelist about 5 to 7 minutes to make the remarks. And then we take questions from all of you. So please feel free to post your questions on YouTube, Twitter, and all our social media handles where you can see the live stream. So coming to Professor Dr. Alexander Fisher, he specializes in comparative constitutional law with reference to India. Before joining the Jindal Global Law School, he was a lecturer at SOAS, the School of Law in the University of London, and the University of Heidelberg. He was a visiting scholar at the Global Legal Studies Center, University of Wisconsin Law School, and a visiting fellow at the Center for Study of Law and Governance, JNU. Mr. Fisher holds degrees from the London School of Economics and from the University of Heidelberg. His most recent publication is a co-edited book, State and Society in South Asia, Themes of Assertion and Recognition. Mr. Gautam Bhatia is a well-known lawyer and prolific legal writer. He is a graduate of the National Law School of India University and of the Universities of Oxford and Yale, where he has completed a master's degree and his PhD. He is also the author of 2 books, The Transformative Constitution and Offend, Shock or Disturb, Freedom of Speech under the Indian Constitution. His work has also been cited by the Indian Supreme Court and numerous high courts in India. Ms. Pragya Surana is a research fellow at the KFG Berlin Potsdam Research Group. She is a graduate of the National Law School, Bangalore as well, and of Harvard. Her research is focused on the impact of the changing geopolitical world order, particularly the rise of emerging powers and how they impact the development of international law. She's currently on sabbatical from OP Jindal Global University, where she worked as an assistant professor. Prior to that, she also worked at the Center for Land Warfare Studies, New Delhi, which is an independent think tank. She's qualified to practice law in New York and India. And last but not least, Dr. Aniruddha Rajput. Dr. Rajput is a member of the United Nations International Law Commission. He has served as the chairperson of the drafting committee of the International Law Commission at its 69th session in 2017. The topic proposed by him, evidence before international courts and tribunals, was put on the long-term program of work of the Commission in 2017. Mr. Rajput advises and appears on behalf of states and private entities before international courts and tribunals, and currently practices as a consultant for public international law and international arbitration at Withers LLP in London. His areas of research and writing and practice are general international law, law of the sea, boundary disputes, international trade and investment law. He is also an author of a book on Ambedkar's vision of Jammu and Kashmir, and was a member of the study group constituted by the Law Commission of India to revise our model bilateral investment treaties. So clearly we have a very eminent panel here, and I would like to first invite Professor Dr. Alexander Fisher to give his insights on the Indian Constitution. As a German-trained lawyer working in India right now, I'm sure you can tell us more about the commonalities and convergences that you see between the Indian Constitution and the German Basic Law. Please, Professor Fisher.
Thank you so much. Your Excellency, other members of this wonderful virtual dais, and also a big namaskar and welcome to all those watching this live stream wherever you are. I'm really exceptionally grateful that I have been invited today. Many thanks also to Neeraj for all the excellent organization. I'm really always excited about any opportunity to experience the 26th of November and the way India celebrates and commemorates Constitution Day. There's a pause a moment of reflection and thinking that is something really special. Unfortunately, this year I'm here in Germany, but next year I hope I'll be back on campus. We do not have this sort of Constitution Day in Germany. I wish we would. And regularly, annually go back in time to the 23rd of May, 1949 as a special day. So as you already learned, both constitutions are quite old, 70 years, which for constitutions is actually quite an old age, sort of the global average over the last 200 years of how long constitutions last is about 19 years. Another thing that an Indian observer will probably notice engaging with the German constitution is that our public constitutional culture, so what was already mentioned, not what the lawyers say and those who professionally deal with the constitution, that sort of the public constitutional culture, the constitutional faith within the population is actually much thinner than in India. And I think I'll try and explain why, and that might be an interesting theme to follow up in our discussion. So I think here India would resemble the United States of America with a strong constitutional faith, much more than Germany. We have something in Germany called constitutional patriotism, but as I said, it's generally considered to be quite thin. We also don't have the relationship that Indians have to Dr. Ambedkar as this one outstanding public figure who's sort of become part of the iconography of India, standing there. I think most statues in India nowadays are Dr. Ambedkar statues, and he's usually standing there with the constitutional text in hand. How do we start our comparison, or how do we think about the German and Indian constitution on this day? And I thought it would be interesting to take you back in time, 70 years, and tell you a little bit about how the constitution in Germany was made. You will immediately see the similarities to India in many, many ways, but also, of course, massive differences. So what you observe today, that we have a strong constitutional core, that we have regular elections, that we have layers of federalism like in India, that we have a powerful constitutional court. All of these things will become clearer if we go back in time and we wonder, we sort of explore why they have come about. Why is the Constitution of Germany called Grundgesetz, basic law? Why do we actually call it constitution? Well, the whole thing was never meant to last. It was a temporary fixture. And if you think of constitutions as something like a love letter to a country, there are different types of love letters, right? I mean, some can be pure joy and celebrations. Others might be written in a mixture of hope and despair. And that's certainly the case for Germany in 1949. The country is in ruin. You have the devastation after the war. 1/3 of all houses and flats have been destroyed. In some cities, 50, 60%. There's widespread hunger. And at the same time, there are 7 million German refugees who had to leave other parts of Europe. So that is sort of the setting in which the German Constituent Assembly meets. And again, a little anecdote that you might find interesting. The members of the German Constituent Assembly, they got a special allowance of firewood. That's how some of their payments were organized. And we also have a historical record. They got a liter of beer every day. They could choose would they take 12 cigarettes or 3 cigars. So I think this tells you something about the time period. The big difference to India, Germany is occupied by the Soviet Union, USA, Britain, and France. And actually, it is these occupying military forces that decide that West Germany should have a constituent assembly. It's not something that is autochthonous, right? I mean, it's a demand from the occupying military powers, which is given to the German state governments in 1948 in June. And in 13 days, so a group of academics, politicians meet, all men. In 13 days, they come up with 149 draft, which is then debated for 8 months, 48 to May 1949, and the constitution is coming into force. So it is called, another thing about the military occupation I should tell you is that all these Constituent Assembly members had their telephones tapped. They had regular meetings with their military supervisors. They were invited to lunches and dinners where they could explain the progress. And of course, when the draft was ready, the occupying military powers could intervene one more time. So for instance, they didn't like the fact that the union government in Germany, the Bundesregierung, was too powerful. Right? So certain changes then were also made in response to that. So in that sense, totally different from India. Yeah. Two little anecdotes from this Constituent Assembly. I've already told you it was all done very quickly, very impressive. If you compare constitution making nowadays, if you think about Nepal or a new constitution in Kenya, Germany, India was very quick, really superb, fast, efficient.
I'm sorry, Krishna, I think Ambassador had another engagement. Just wanted to let the audience know.
Yeah.
Please go ahead.
Yeah. So let me just say how many women were there in the German Constituent Assembly. It was a small assembly, 65 members, 4 women. And so like in India, there are very few mothers of the constitution. In India, there were 13. And I actually think that those 13 Indian women had it actually easier than the 4 German women, because they had to spend a lot of time and effort to just get the equality guarantee for women into the German constitution. The Weimar Constitution had just said women are equal as citizens of the state. They were not granted legal equality when it came to civil law, family, and these other things. So that was quite a process, took over months. And very nice political maneuvering. These 4 women invited German women to send in letters. So there was enormous amounts of posts came in. And they also twisted the arms of the wives of the male members of the Constituent Assembly. So eventually they got it in. And I'll tell you later why I think this is an anecdote to remember. The other interesting anecdote I wanted to tell you is there were 2 criminals in Germany on death row since 1946, 47. And while the German Constituent Assembly was debating whether to abolish the death penalty, one of them was actually executed. They didn't hang people, they used the guillotine, right? You know, this from the French Revolution, this gigantic blade that falls down. The other person, a woman, was said to be executed, but in that federal state, they didn't have a guillotine at that point of time, and they tried to build one. And so they, because it was after the war, it was difficult to build, but also 14, sort of professional blade sword makers who they asked to build the blade of this guillotine refused to build it. Yeah. So, and then they built it actually, and you can still go to a museum and see it, but she was not executed. Something with her testimony was wrong, so it was stayed. And then the Constituent Assembly decided to abolish the death penalty. And the only reason why they were able to do this is because it was split. It was almost a perfect split in the Constituent Assembly. And days before they had to vote on it, the man who was fighting to keep the death penalty had a car accident. So he couldn't come for the vote. And so it passed. Yeah. And this woman would have died, but then she didn't, and she was released from prison in 1970. So you see, it's a very, very different situation from India, which has, I think, a true founding moment. Pratap Banumeta has this wonderful sentence where he says there have been 3 constitutional moments. You have the US and the French constitutional moment, which sort of starts modern constitutional history. And then you have India as the true first post-colonial constitution. And when you compare to Germany, how timid many of the ambitions were, you have the Indian Constituent Assembly stepping in. As I said, I feel things like the equality for women. It's much easier to agree on this in the Indian Constituent Assembly. Don't forget that women in Switzerland, for instance, couldn't vote until the 1970s in some of the cantons. Yeah? I mean, this is not even debated in India. In the United States, interracial marriage is illegal in the southern states until 1967. There's not even a hint of a debate of racial, nobody problematizes racial equality. And then you have Article 17 with respect to caste. So it's this enormously bold and ambitious moment. And then also a few years later, in 1956, with the states reorganization, again, India tackles this issue of multilingualism, which has brought down so many other constitutional states who have failed in that respect. And India does this in a democratic setup even, which is, to my knowledge, the largest democratic and peaceful constitutional reform when you think that it affected the lives quite dramatically of 600 million people in those days. Yeah, so I think later on, today is maybe also a day to celebrate the success stories of constitutional law. And one thing you can take away from this already is that the success of the Indian Constitution is sort of in a whole different category of the German basic law. And maybe I can later on explain you a little bit why I think that is the case. Thank you so much for your attention.
Thank you so much, Professor Fisher. Now moving on to Gautam. Gautam, you had written this book, Transformative Constitution, and you argued about how the Supreme Court in this interpretation moved from a formalistic textual sort of Supreme Court just imposing the laws to much more playing a more active role in the decades going forward. Maybe you could throw some more light on these issues. Thanks.
Yeah, thank you. As a comparative constitutional lawyer, I'm always really fascinated by the unexpected similarities that tend to come to light when you examine constitutions and their development more closely. And in that sense, there are similarities in the evolution of the German Basic Law and the Indian Constitution as questions of doctrine. So, just tying up with what you said about the way the Indian court has interpreted the Constitution over the years, that's a good entry point. But before I go to that, I just wanted to highlight something that to me is very interesting, which is that in the Article 1 of the German Basic Law, it begins with saying that the dignity of man shall be inviolable, and dignity as a lodestar of the German Basic Law is something that is very much part of the discussion, and often in a very reductive way when people distinguish between, say, American constitutionalism and, say, German constitutionalism. They talk about how the American constitutionalism, the fundamental idea is that of liberty, and in the German constitution is of dignity. And of course, that's a little reductive, but that's, you can see how the kind of pull that idea exercises because of the history in which the German Basic Law was framed and what they were responding to. And it's interesting that the preamble of the Indian Constitution begins with we the people of India, and then it has a list of things that the people of India resolve to make part of the Constitution. And one of them is to ensure fraternity, assuring the dignity of the individual and the unity and integrity of the nation. And the really interesting thing is that this was the initial draft of the Constitution, and when the draft was opened up for public comment, it went through 3 rounds of framing. When the draft was opened up for public comment, a very powerful faction of the Congress party also had the majority in the assembly, led by a former chairperson of the Congress party, wanted to reverse the order of this phrase. They wanted to first put unity of the nation and then put dignity of the individual. So they proposed that change in the wording. And B.N. Rao, who was the constitutional advisor, he rejected that change in the wording, and he said that if you assure the dignity of every individual, the unity of the nation will follow from that. And when it was put to vote, B.N. Rao's views were accepted. And that's why you have the formulation now, which goes fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So there's a very interesting history behind this phrase, which also goes to show you that much like the framing of the German Constitution, there was actually a discussion about the meaning of dignity, and the importance dignity would play as a central constitutional value. And there actually was, a debate about whether, should unity come first or dignity come first. And then finally, the idea was that, if you're going to assure dignity to every individual, then unity will follow from that. And so in that way, these ideas of dignity and how it relates to national unity it's interesting to think about how both of them form a basis for these two constitutional documents. Um, Moving on then to evolution and interpretation, there are two or three, I think, areas where some very interesting similarities come about between the two constitutional documents. The first is the idea of proportionality. So again, there is a popular idea that if you look at American constitutionalism, then that's categorical constitutionalism. You have like specific categories of rights that are enforced. There's no conception of balancing, between rights and obligations and so on. Very early on in the development and the evolution of German constitutionalism, we see this idea of proportionality summed up in a very memorable phrase that if you want to shoot a sparrow, you don't use a cannon. That's the German articulation in the early days of what proportionality means. And of course, that then is exported all over the world, and now proportionality is kind of this really global constitutional doctrine. The interesting thing is that just at around the same time in 1952, in a judgment called V.G. Rao that involved the banning of organizations in India, the Supreme Court of India, while reversing the ban on an organization, also articulates something that is very similar to proportionality, although it doesn't call it proportionality. So the Supreme Court of India says in that case that you have to look at the object of the law, look at the nature of the right, look at the extent of the restriction, look at if there is any other possible way to achieve that goal in a less restrictive way. And taking into account this entire spectrum of issues, placing it in its relevant context, then you can understand if a restriction upon a right is reasonable or not. And these are all the elements that would go on to become the test of proportionality in various jurisdictions. So you can see again that in different language and in different contexts, in both in Germany and in India, there is a broad idea that if the state wants to restrict rights, then it needs to do so in a proportionate way. And of course, many years later, in 2016, the Indian Supreme Court, after many decades of this principle evolving, would finally officially call it proportionality. And now that's become part of Indian constitutional jurisprudence as well. So we have taken a slightly different route to get there. We have taken different language to get there. But the basic underlying idea that you have to that reasonableness and restrictions of rights has to follow a proportionate form. That's been something that's been part of both of the jurisprudence of both countries almost since the beginning of constitutional evolution in both countries. The next, of course, is the basic structure doctrine, which the ambassador touched upon. And it's interesting that so in the Southwest case in Germany, very early on, I think 1951, if I remember correctly, there is this articulation that a constitution is not a disparate set of provisions just randomly thrown together, into a document, but it has a certain internal coherence, a certain internal unity, and the separate provisions go into constructing that unity. So there is a unity of theme, a unity of idea. It's not just a rag bag of different provisions. And the German scholar Dietrich Conrad, of course, conceptualizes that idea in terms of a basic structure to a constitution. In 1973, after many false starts and debates, the Indian Supreme Court accepts that doctrine. It relies upon Dietrich Conrad's writings, and it says that it frames this idea of the basic structure in terms of constitutional identity, which is that every constitution has an identity that flows from its provisions and its basic features. And that identity is not something that can be amended using internal amending power. If you want to change that identity, you have to go extra constitutional. There needs to be a revolution or a fresh constitution. But that constitution is not subject to alteration in this fashion. And that's the origins of the idea are German. And I think that what's also very interesting is that the idea's origins are German, but it's now understood all over the world as having an Indian doctrine. So in that, there's a bit of a synergy there. And recently, the High Court and the Court of Appeal in Kenya accepted the basic structure doctrine as being part of Kenyan jurisprudence. And what's interesting is if you read those judgments, they draw upon both German sources, Dietrich Conrad, as well as the Indian Supreme Court. And so it's almost as if Dietrich Conrad provides the philosophical basis of the doctrine. The Indian Supreme Court provides the judicial articulation of the doctrine, and together now they form this overarching structure, which is both judicial and theoretical, that other countries are now adopting and modifying to fit their own circumstances. And in that way, I think it's not just a function of say a convergence between the Indian constitution and the German basic law, but how together they've provided this really powerful tool to prevent constitutional abuse and prevent constitutional mutilation. The last thing I'll talk about very briefly is the idea of indirect horizontality. And so in German constitutional law, starting with the Luth case, you have the idea that the constitution is not just negative rights that individuals hold against the state, but actually it radiates throughout the entire private law domain. And private law general clauses, such as say in a contract act or in other private law statutory instruments, can become the gateways through which constitutional values can then enter into the private domain. So there's no domain of private law that is entirely insulated from constitutional scrutiny. And you see again in India as well, this idea taking root through such ideas such as constitutional public policy. So the Supreme Court holds that the public policy exception to contracts in India has to be informed by constitutional values. And so if there is a contract that is, in a sense, opposed to the values of the Constitution, then that contract need not be enforced. But of course, you can't directly apply the Constitution to it. You have to make the argument that public policy informed by the Constitution vitiates this particular contract. And so in a similar way, that is an application of indirect horizontality, which is that you are applying constitutional law to private relations, not directly to the parties involved, but through existing law like private law. So I think that if you look at these various ideas, the basic structure, proportionality, horizontality in this indirect format, you see how both sets of courts are groping towards similar ideas, using at times different constitutional language. But the migration of ideas is very fascinating to see. So I think that would be my contribution to this discussion, and forward to the Q&A.
Thank you so much, Gautam. Now, moving on to Pragya. Pragya, let's look a little outward. The ambassador mentioned, how several constitutions that emerged in the 20th century in the whole post-war, post-colonial context, they all had this strong focus on human rights and universal liberalism. And you also see important international conventions like the UDHR and all that, all of this happening within a span of a few years. So maybe you could give us a brief snapshot of that period in our world history and what was going on there and how it informs our topic and theme today.
Thank you. So you see that the world was collectively dealing with these events. The World War had just happened and the Holocaust had happened. The entire world was grappling with how can we best deal with these scenarios so that they never happen again. That's also where the roots of international law in its modern form originated. And you will see that all of these ideas of world peace are reflected across constitutions and in the UDHR as well. So you'll see that over 40 something constitutions that were drafted in that era actually had references to things like arbitration as a method to solve disputes among nations or world peace. And the Indian Constitution is very much a product of its time in that it has all of these concepts as well, and including the UDHR. So I want to actually focus on the role that some prominent women played in the drafting of both the Constitution and then the UDHR. So it actually jumps off very well from where Professor Fisher left us. And I want to take us back to the drafting history of the Constitution. And you're right that we know so much more about Ambedkar and B.N. Rao and all of their philosophies, but we don't know that much about the actual role that these women played. And given that it was a very patriarchal society, it's quite impressive that they managed to get as far as they did. So 15 women were part of the Constituent Assembly, and they not only were there as puppets, but they played an active role and fought for the rights of women and other rights that I'll just go briefly over. So there was a subcommittee on the fundamental and minority rights. This is one of the smaller committees formed by the Constituent Assembly to discuss the content of what the fundamental rights should be. And this is also what we recognize today as equality and religious freedoms, etc. So it's interesting that Hansa Mehta and Rajkumari Amrit Rao were both part of this committee, and they actively spoke about how the legislation and how the constitutional provisions should interact with each other so that they can best promote the rights of all citizens. So there's this one joint letter where they wrote about religious protection. And when that was being discussed, they also said that religion in India has been used to perpetuate unequal customs for so long. So we don't want to create a scenario where the constitution protects religion to the degree that the legislature cannot then counter these unequal customs such as parda, child marriage, polygamy, unequal laws of inheritance, prevention of intercaste marriages, and dedication of girls to temples. So they're very aware of this background and the role that they played in protecting the rights. Rajkumari Amrit Rao was also Amrit Kaur was also a supporter of joint electorates. So it's sort of dividing the country on grounds of sex or religion. She was firmly of the belief that everyone should vote for everyone. So you won't have a separate electorate where only the Muslims vote for the Muslims, or the Hindus for the Hindus, or women for women. They strongly opposed such division. And she wanted to promote this idea of this common nationalhood, where we all recognize and understand our heritage as one. And these positions actually ultimately did prevail. And at a time when the country was going through partition and there were religious riots, you'll see that there was a very tense atmosphere for India and these founding framers to take this very secular position is quite inspiring, and it continues to be a central value in the Constitution even today. In another note regarding the manner in which minorities should be protected, she spoke of how equality before the law and in society and equal opportunity for education and service are all we claim as human beings. And I believe that in the proper fulfillment of our duties as citizens, and duties must go hand in hand with rights, lies our best safeguard. So Professor Fisher spoke about how difficult it was to get these equality provisions out there in the German constitution. You will see that these people also faced similar backgrounds and unspoken biases, but they fought for these rights, and the manner in which they wanted equality provisions to take root in the constitution is also very interesting. And you'll also see that some of these women came from very privileged backgrounds, but were very aware of the social reality of the country. So in one instance, the Special Marriage Act was opposed. At that point, it did not allow people of different religions to marry each other within the country. So she spoke about how only the very rich can leave the country and get married, and it fundamentally affects, like, there's a socio-economic impact of that law. And there was also a Muslim woman in the Constituent Assembly, Begum Ezaz Rasool, and she also supported joint electorates instead of dividing the country by religion. So you see this idea of unity really shining through all of these contributions that these people have made. And Begum Ezaz Rasool also spoke about how proportional representation would not work in a country like India. And that's one of the reasons she supported this joint electorate where everyone votes for one person. And that's actually really true, because at that point, it was visionary to adopt universal adult franchisee in a country where the literacy rate was 12%. So you see this beautiful vision that these people collectively have for society, and that really shines through in our constitution. Hansa Mehta, who I referred to earlier as a prominent equality rights advocate in India, also was a part of the drafting committee of the UDHR, the Universal Declaration of Human Rights, which is a central document talking about equality and dignity and really reinforcing these concepts across international law. So she was actually quite prominent, and even at the international, in the international sphere, she included the, instead of the rights and dignity of man, she included the phrase of human beings. So it became equality of human beings. And she fought for the inclusion of color along with race to ensure that there is no confusion whatsoever. And you'll see that these ideas really traveled across the world at that time. And they traveled from constitutions to the international sphere and from the international sphere to the constitutions. And you'll see that there was a collective vision for society, which is reflected across all of these. I'll just end with one last anecdote about Sarojini Naidu, who was also another woman who was part of the Constituent Assembly. And this really draws to the moment, the historic moment, and leading up from the freedom struggle, and really owning this idea that this should be our heritage. So she gave a deeply moving speech when the national flag was being adopted, and she had represented India across various international conferences and had spoken about the anguish of not having a national flag and what that meant for the people of the across the world. So, in fact, she refers specifically to this one anecdote where they were in Berlin and there was an international women's conference, and the various nations decided to hold a flag parade. And India at that point did not have a flag. So these women who were part of the delegation stayed up all night. They literally tore pieces from their saris and stitched it into a national flag and stayed up until the early hours of the morning so that they could have this representation and that India could be represented at the global stage. And you'll see that the adoption of the constitution and each of the various elements of the constitution was truly this historic moment of pride for Indians. And it is this spirit that we should reflect on and celebrate today. Thank you.
Thank you so much, Pragya. Now moving on to our final speaker, Dr. Rajput. Aniruddha, I think maybe you could, as an Indian trained lawyer now working abroad, maybe you could give us some insights and weigh in about where you see the convergences between these two constitutions, and also maybe look into the future as to how you think our constitution is going to go forward and so on. Thank you.
Thank you very much. Also, thank you to Ambassador Harish for this very thoughtful initiative and the generous invitation to be here and speak. It's a pleasure to be a part of this fascinating panel. I feel a bit of an outsider, but being an Indian, having practiced in the Supreme Court of India with the first case being the second largest bench after Keshavananda Bharati, the IR Coelho, I think I probably have the time to refresh some of the things, some of the reflections from practice and the book that I wrote about Ambedkar's vision of India. So it's a great pleasure to be here. I think the first point of conversion is really speaking volumes about what we are trying to compare. The embedded idea in the word convergence is whatever is converging starts from some different starting points, and at some point of time it comes together and then synthesizes and then eventually develops in the future. And that's what is continuing evolution. And I think the Indian and the German constitution, not the constitution, the basic law, which is the right word, because it was supposed to be a stopgap arrangement, which ended being a perpetual arrangement, is to how they evolved distinctly. And now we see several commonalities between them. And I want to highlight how this process of conversion ought to be seen. Often what happens is we look at the history with the lens that we are using now, without realizing that our lens is probably advanced or maligned by our own thinking. And we try to put our views on what must have been thought. So I think it really helps to put our lens away and look at the situation. how it evolved then, and then try to grasp as to what might have gone in the minds of the makers of the Constitution. Probably I think we need to change from constitutional fathers to constitutional mothers, because mother in a sense includes a man, she includes he. So I think we probably need to move towards that. And that's my first point. There's a major contrast, which was Professor Fischer very rightly pointed out, about the German Constitution and the Indian Constitution with 15 women. But what we see, and that was, I think, a very good point that Ms. Surana just made, was we do see a contrast here, that they seem to have been pretty much embedded into the constitution making process rather than having had to fight for their right or having had to find a place for themselves, which also shows a certain degree of underlying transformation, and also to a certain degree the transition and the ancient understandings of the Indian culture and the society. So how I look at the constitution making process is, of course, the constitution was looking around the world. It was looking at different constitutions. It was looking at international developments. But if we go through the drafting history, if we just read the Constituent Assembly debates, we find a whole lot of reference to these ancient texts, not just Hindu religious texts, but to Islamic texts. And all these references are trying to build upon the ancient tradition of India. So there was this very famous saying by Iqbal. Unfortunately, he was the person who eventually proposed the two-nation theory and the concept of Pakistan. And he wrote a very interesting poem, probably for an international audience. I'm not sure if it would resonate, but the essence of the poem is that the Egyptian culture is not there anymore. The Greek culture is not there anymore. The Mesopotamians are not there anymore, but India has survived because it has continually evolved. And even if the world has attacked us, we have absorbed our attackers and made them a part of our culture. So we do see this long historical evolution, and not just Western education of those scholars. So we do have Sarvapalli Radhakrishnan, who is fluent in all the languages. He's speaking fantastic English, knowing English texts, but still wearing a turban. And we do see that in most of the participants in the Constituent Assembly. They're not shy about their history. They're not shy about their past. So in a sense, in one hand, they're carrying their history, and in the other, they're also looking into the future. So what we do see that to a certain extent, they're looking back towards the historical, say probably the Shankaracharya debate of Prabhavati Devi and Shankaracharya, where women were not just as good as men, but they were superior to men, so they could judge two intellectuals and then decide who's a smarter guy, even if one of them is her husband. So we do see those signs of somehow trying to also gather those pieces of the ancient history, but make sure not get bogged down by some of the patriarchal distortions which evolved in the society, because it's bound to happen when a society lives over a much longer period of time and survives as a fairly existing community. So we do see these differences. And what we do see in the Constituent Assembly debates, that we don't have the kind of contestations that we see today. So gender equality doesn't seem to be such a serious issue. Yes, they're aware that within the families and the way in which the society is functioning, there are problems. We need to improve the society. But when it comes to universal adult suffrage, it seems to be a done deal. That's not something massive which women had to fight in Western countries in so-called advanced democracies. So we do see a very interesting origin of the making of the Indian Constitution. And I think the most important fact is that none of the drafters of the Indian Constitution were functioning under the threat of the guillotine, or probably the threat of an occupying power. So that freedom of thinking and that freedom of thought, the freedom of expression, I think is very well reflected in the constitution making process. Therefore, quite interestingly, Pandit Nehru said the preamble is the most beautiful poem in the world. And one of the first amendments to the Indian Constitution was to narrow the fundamental rights, right to property, because as a prime minister, he started facing problems of expansive fundamental rights. So we do see this whole set of aspirations, and then a set of practical issues which the constitution makers faced while making the constitution. And that's where I think is the difference, because the pressure aspect which we see in the German constitution making is absent, because all these participants in the Indian Constituent Assembly have themselves been a part of the independence movement. They have all been educated in the Western culture, but equally embedded in the Indian culture. So they could think innovatively, think more independently. Probably they valued independence than anybody else who could appreciate and understand the importance of that. So we can't forget that aspect of absence or less seriousness of contestations. I think absence of contestations would be a wrong proposition to make. In terms of world peace, since I spend most of my time thinking about international law nowadays, so also what we see, the concept of world peace that the makers of the Constitution have does not come from the UN Charter. They say, of course, there is something, the UN Charter, which is existing, which is very good. But our concept of world peace comes from our own traditions, because there's this very interesting set of recitation which I came to know when I was fascinated and I did a course on Vedas. And there's something called Prithvi Sukta. So this is a prayer to the earth where they're saying how we have to make the world peaceful. There's something called Shanti Path as well, where you say peace for everything. And it's basically trying to say the once you're peaceful inside, then you reach the ultimate reality and all those things. And I think these things could probably resonate in Germany, because we can't forget Hermann Hesse's most famous novel, Gotham, which was a big fascination in the 70s. So, which also in a sense brings the two cultures, despite having different origins, so many diversities. Of course, the diversities of the entire Europe even clubbed together can't compete with the diversity that India inherited and the makers of the Constitution inherited. So we do see all these ideas reflected very well. And in a sense, if I have to sort of single out what's the commonality, the theoretical commonality between the German Constitution as it has evolved, the German basic law as it has evolved, and the Indian Constitution, I think it's really the balance. It's an effort to balance several competing objectives. And that explains how these constitutions have evolved over the time. And I think that balancing factor comes out more prominently after the collapse of the Berlin Wall. And that's when, in a sense, the same group of people who were subjected to very different political culture for a long time get together, trying to balance out whatever influence they have had in order to ensure that they grow together in a much solid form as a single community, as a society. And therefore, we do see a lot of the social ideas which are so deeply embedded in the German governance structure, and also to a great extent in the continental European structure, unlike, say, the American structure, which is very much on the edge of the market capitalism and very much individualistic. And therefore, we do see on freedom of expression, of course, every individual has a freedom of expression in India and in Germany, unlike the American freedom of expression, which is just, you are free to do what you feel like. It's just free, you're just free. But there are balancing factors within the German Constitution and the Indian Constitution. So, and that comes from this traditional understanding that, well, I have my freedom, but I have to be respectful towards somebody else. That should not imply that the state is going to deprive me of my freedoms. That's I think, very important. And I often like the statement made by Dr. Ambedkar on Article 32, and where he describes Article 32 and says, if there's anything which is most critical to this constitution, most critical for this country to survive, it is this provision. And this is the most important provision which is going to make sure that the rights of people are not trampled by the government despite its changes or what it happens. So I think it's an interesting point of convergence where these two constitutions begin at in a very different background, in a very different context. One with a lot of freedom to decide and choose, the other under certain pressures, but they seem to have converged now and finding a lot of commonalities. And there seems to be a certain degree of attraction between the two cultures as well. In fact, Max Muller was one of the prominent German to point out these commonalities. There's a very interesting lecture which he gave in Cambridge to ICS officials saying what the West can learn from India. So it was probably the first individual in the European context who came out to say, well, you probably need to learn something from these guys as well. So it's also a certain degree of unexplained connection, which probably explains this convergence. And what might seem as an accidental convergence is also going to be something which would help in the future for both both the judicial institutions, even the functioning of the executive, as either of them tread into rough waters, because in democracy, eternal vigilance is the price, and any complacency is dangerous. So the balance has to be there, the balance has to be retained, and the balance has to evolve. So it will be quite fascinating to see how both these constitutions evolve individually, but at the same time while influencing each other in a manner to enrich both of them. And in the future context of in the grander scheme of things of enriching how the whole world looks at the constitutional relationship, mutual relationship, and world peace. Thank you.
So thank you so much, Dr. Rajput. I think now I'll try to take as many questions as I can in the limited time that we have. So I think this question could be answered by Dr. Fisher. You spoke about how the average age of some of these constitutions was just 19 years in the 20th century, and how, in relatively speaking, the Indian and the Basic Law and the Indian Constitution are fairly long constitutions. I mean, they have a long history and they've endured for quite a while. How well, and given the fact that it was not meant to be a permanent constitution, how well do you think the Basic Law, how well is the Basic Law equipped to deal with the challenges that Germany is likely to face in the future and going forward? What do you think? What's your prognosis for this?
So going forward in the future, I think we see a little bit of a crisis of state capacity in Germany. But that might not be mainly a constitutional problem in terms of the constitutional text. I don't think there's any problem there. But I think, after a long period of neoliberal ideology, this dominance, the dominant idea of balanced budgets and things like that, we see that what we used to take for granted, the capacity of the executive to deliver legislative initiatives, that lead to large-scale reforms as acts of parliament, where you don't have to rely on the Constitutional Court to settle the problems of our time. I think that is missing, but now we have a new government, and their first efforts were to bring back this idea of a political will to change and to take on large infrastructure projects, to talk about investment. And of course, the dominant theme here that might be interesting for Indians, it's non-stop climate change. And the entire year we were busy talking about our climate change legislation. And the climate change legislation had said we should be CO2 neutral in 2050. So that was the legislation passed by Parliament. Some younger Germans took it to the Constitutional Court, and the German Constitutional Court has declared this is not good enough. It has to be 2045, because otherwise there's a huge intergenerational injustice, right? I mean, sort of the older generation now uses up the last CO2 reserves that we can still sort of put out there in the atmosphere. So climate change obviously is going to be the dominating theme. The German constitution is also deeply embedded into the European unification process. In that sense, it's completely different from India. To what extent, there we also saw tied up, it's like an interdependency trap. Where even if you did a bold constitutional reform, you're still tied to the European Central Bank, the European Parliament, the European treaties. And definitely nobody wants a Brexit in Germany. I mean, that's never going to happen. So I would say I don't see any specific shortcomings in the German constitution. as far as constitutional text is concerned. I think Germany and India both have a problem in terms of parliament and politicians that are no longer capable to implement large-scale constitutional reforms. I know there have been lots of little amendments passed in India and lots of amendments in Germany, but this capacity, like the States Reorganization Commission, or the boldness to introduce Panchayati Raj for all its failures. These politicians who are capable of drafting and seeing through major constitutional reform, that's deeply missing at the moment. So, there's not a fault of the Constitution. The amendment process is there. It's just there is no, the skill for constitutional politics is very low. And then it ends up on the shoulders of the judiciary, and there's only so much the judiciary can do, right? Even if you have 8 or 9 perfect judges. Courts have no sword, courts have no purse. It'll just end somewhere in terms of judicial capacity. So I think the thing missing most when I think about the German and Indian constitution that worries me is the lack of ambition of constitutional reform.
Thank you so much. Maybe this question I could ask Gautam. One of the common criticisms of the Constitution is that most of it, you call it a transformative text, but the question is most of it comes from colonial documents, like I'm assuming they mean the Government of India Act and so on and so forth. So how would you respond to that? How would you respond to that criticism?
Yeah, that's a fair criticism. 75% of the Constitution of India comes from the Government of India Act. A large part of the administrative structures are carried forward from the Government of India Act to the Indian Constitution. And in fact, there's a very interesting book that came out recently by Arvind Alangovan. It's called it's about B.N. Rao, and it talks about how B.N. Rao's whole vision was that the 1935 Government of India Act was itself meant to be treated as a proto-constitution, and the book talks about how that vision was frustrated because of the political situation and the political actors of the British government, the Congress Party and the Muslim League. So I think that the story is quite complicated. What I would say is that I think what's important to understand is that a constitution is not completely determined by its origins or the context of its origins. It's of course influenced by that, but it's not determined by that. It's determined afterwards by what people make of it, by what adjudicatory bodies make of it, by what the elected representatives make of it, because these are all actors involved in contesting upon the constitutional terrain. And I think, therefore, if you look at the trajectory of the Constitution after its framing, you see that contestation playing out. And then in some circumstances, you have courts articulating, perhaps a more conservative idea of the Constitution, one that, in a certain sense, continues to take forward some of the impulses of the colonial times, like a centralizing impulse, the emergency powers, and so on. But you also have another tradition of judgments, of popular interpretations of the Constitution that is transformative in character. And one could take many examples. Perhaps a few prominent examples would be of course, the Navtej Johar judgment decriminalizing same-sex relations, that is specifically grounded in a transformative idea of liberty that prohibits the government from using traits that are either intrinsic or fundamental to identity to discriminate, and locating that trajectory or a certain history of constitutional evolution. So you do have judgments like that as well. And so I think, like, ultimately constitutional terrain is a terrain of contestation where different impulses kind of compete, and there is a strong transformative impulse that has been part of our constitutional tradition ever since its inception and before, in various movements for liberty, freedom, Dr. Ambedkar's movements, as well. And it's a question of what we make of it, and if we can succeed in making the transformative impulse, part of the Constitution, that's on us as the interpreters, as the public, as judges, and so on.
Thank you so much. This is an interesting question. I think I'll first maybe give to Pragya and then to Aniruddha. You referred to convergences between Indian and Constitution and German basic law. And how do you see these evolving in the future? And what are the international trends that might stimulate or impede them?
So I think Mr. Bhatia already mentioned how Navtej Singh Johar and there are other transformative constitutional judgments in India that have come about. It's interesting to see that there's also been greater reliance on movements around the world and developments internationally that shape how equality and dignity, these very fundamental constitutional values, are interpreted by the Supreme Court back home. So you'll see that the Yogyakarta principles, which talk about sexual orientation and gender rights, became a fundamental part of the Indian jurisprudence because they shed light on equality as it is now seen and as societies evolved. So these ideas and movements around the world will continue shaping our understanding of the jurisprudence and of our own original constitutional values. And this has also been mentioned by Mr. Rajput, where he spoke about how the constitution evolves with time, and how Indian constitutions and Indian culture has evolved over time to stay relevant. And this continuous evolution does seem to keep taking place. And it's partly why I think we have one of the longest constitutions by the average standards. You're muted.
Sorry about that. Always happens once every Zoom call. So Aniruddha, what do you have? Would you like to weigh in on this? What do you see as the international trends which would, either impede or, of course, stimulate these larger convergences and evolution?
At the national level, the most prominent thing is judicial dialogue. And over the years, what has happened that judicial dialogue has become far more intense than before. It's, of course, the availability of technology, far more international cases are cited before national courts, which increases the possibility of exploring some of the ideas. And it's often rightly commented that the Indian Supreme Court is more leaning towards the American Supreme Court, but it's time for the Indian Supreme Court to also pause and to look at how things are evolving in other jurisdictions. And to that extent, if one looks at the German system, German constitutional system, it moves steadily. It doesn't make any drastic transformation. It is very much reflective of its society, reflective of its economy, and reflective of its laws generally. And for a society of the kind that we have in India, with so many diversities, and the reason why I was highlighting the point of contestations was because our makers of the constitutions were aware of it. If contestations begin, it will be a ruthless, unending battle. We can't resolve it the way it was resolved in Europe. We have to find our own way, the way we have coexisted. So there's a contestation with a mutual respect of survival and existence, where I don't have to ensure others go and it's just me who's there. So that idea, I think, would continue to influence and would continue to sort of go around the world. And I think it's really about how well the Indian structures, not just the judiciary, but the executive, absorbs dissent, how well it responds to that, and how well it moves around the world. So that's, I think, one thing is important. Looking at it from the international level, I think there's some serious concerns for international law. I wouldn't say it's a crisis moment yet, but we might be heading towards one. And often because in a society with several billions, if there's one crisis, it impacts so many. In a society of 196 member states, even a smaller crisis tends to be considered as a huge crisis. For in the context of international law, even a minor diplomatic incident can be treated as something massive. But we might head towards a situation which would really create troubles for our international community, and that's where I think international community needs to learn a lot more from the domestic systems. And one issue on which the International Law Commission is working is general principles of law. And one of the ideas that has been going on is these general principles of law ought to come from different jurisdictions and different legal traditions. So they should come from all traditions around the world and not just the civil and the common law. And as we move forward, I'm very sure that there's more space for some of these ideas to be accommodated and to evolve not just the domestic understanding of these issues, but also of international law generally.
Thank you so much, Aniruddha. No, this is an interesting question. Maybe Gautam, you could take this one. The Indian Constitution is often called the longest constitution in the world. Why is it so? And how would you compare this with the German Basic Law? So maybe first you, and then I'll go on to Dr. Fisher.
Yeah, it's one of the longest and has 391 articles, but that's actually a little misleading because many of those articles actually are mini constitutions within themselves. So look at the sixth schedule. You'll see a full constitutional framework for indigenous areas. You later had Article 243 that I think goes to ZZG or something. That's the local government provisions that came in the 1980s. Yeah, no, so so there are historical reasons why it's that long. And the major historical reason is that that the framers of the Constitution, basically, given the context that we're operating in, wanted to not just have a statement of principles, but a very detailed administrative framework that would set out as much as possible and leave as little as possible to being worked out in the course of things. Because you need to remember that unlike, say, in the UK or elsewhere, where parliamentary democracy kind of grew over 300 or 400 years, that is specifically in the specific form that it is, grew over 300, 400 years, trial and error, revolutions, all of that. And so conventions evolved over time. In India, an apparatus of framework of government in these specific terms was effectively being constructed with a very short history. 1909 is the first time that you have the kinds of institutions that we recognize today appearing in their proto form. So in that way, the experience of governance in this fashion had a much shorter history than elsewhere, and was also something that still was being worked out. And so for that reason, you'll see that all the details are set out in the document itself, so that the charter or the blueprint is right there, and it's not something you have to work out through conventions and things like that. That's actually why that it explains the length of the document relative to many other constitutions, including the German Basic Law as well.
Right. Thank you for that. This question maybe Dr. Fisher could answer. Would you agree with those who say that Part 3 of the Constitution of India, which deals with fundamental rights, and Articles 1 to 20 are comparable? And how would you compare and contrast the rights guaranteed by our Constitution, I'm guessing he means the Constitution of India, versus the Basic Law?
Okay. Can I just ask, do you also want me to comment on the length?
Yeah, of course, both. Yeah.
Yeah. Okay. This might take some time. I think you have, of course, this historical continuity with the Government of India Act, which means, and as we also know, the Constituent Assembly was working at a point of time when there was a crisis. So maybe they had planned to, sort out specific issues later. So you find various things like retirement ages of civil servants and specific provisions with the judiciary, a lot of stuff that in most countries is just in a simple act, or even just an executive order or something, you will find in the Indian constitutional text, right? And then it's also really absurd to say that the 105 constitutional amendments in any sort of way, many people frame this as a problem, or it's been amended too often. Why has the American Constitution only been amended 27 times? That's because there is so much stuff in there, which in other countries would never require a constitutional amendment. And that's just partially a historical accident. I think it does matter because it reduces the readability of the Indian constitution, right? I mean, it's impossible for the German constitution, which has 183 articles now, for a German citizen like my daughter, to pick it up and to just start reading it. So I think in that sense, it's an issue, and I might, I can invite everybody in the audience from India to come to the website of the German Constitutional Court or the German government, and there is an issue called readability, right? And the idea is to communicate the meaning, to change the language of the constitutional text and to change the language of the Constitutional Court judgments to make them easier to understand. So I think in that sense, it does matter. The German constitution is about 10,000 words. With unification and European law developments, it has grown by about 30 articles. 3 were taken out, 30 were added. So now it's about 17,000 words. Length also in a federal constitution where you have legislative competence, these long lists, that's also a reason why you have, and then also India is just a gigantic country, right? I mean, just list the languages and you have a long constitution. I think part 3 of the Indian constitution and fundamental rights in Germany are definitely comparable. I think actually you can get a lot out of this comparison. If you take freedom of speech, for instance, this is one of those examples where I would say, what we do when I teach in India and we do Article 19.1a, there is so much jurisprudence, right? With respect to public morality, public order, and the constitutional amendments that came. But there are so many questions that are left open to judicial interventions, which in other countries are just like South Africa or Germany, in the free speech article are just crystal clear, right? So you read the German free speech article, academic freedom or the academic of the arts is, the freedom of the arts is explicitly mentioned. And so this again would bring me back to my earlier observation, yes, you can compare it. Why do you compare it? I think after 70 years, a lot of issues have piled up in constitutional jurisprudence in India, where a cleaning up of the language of the fundamental rights of part 3 might be a good idea, right? I mean, you have all these footnotes with the constitutional amendments. And I think especially when it comes to limitation clauses, right? What are the reasons why we limit rights? I think there, if you look at the South African constitution or the German constitution, there's just a lot more clarity. And I think in that sense, constitutional text here can make a difference. So definitely comparable, makes a lot of sense. And maybe add South Africa, which is sort of one of the latest, most beautifully and well-designed constitutional texts.
Thank you so much, Dr. Fisher. Okay, maybe this one Pragya could take. How would you respond to the argument that the composition of the Constituent Assembly was not based on universal franchise or direct elections? Instead, we saw indirect elections and for example, representatives of princely states play an outsized role. How does this tie into your argument that there was a lot of diversity and there's a lot of diverse thoughts and ideologies that came into play at that point during our founding moment?
I think the two don't have to be in opposition to each other. So also there is a historical moment. These princely states are being integrated into the nation. So they had to play the role they did. And you'll see that the constitution that did come about reflected all of these various ideologies and ideas. So you'll see from, say, the communists to the extreme right wing, you'll see all of these discussions and debates take place in the Constituent Assembly. And all of these ideas are made coherent into this one document. And it can also be said that even though it was not by direct election, the document that we have does embody the ideas that we would want for the nation. So we have universal adult franchise, we have equality, And we have a lot of members very aware of the socio-economic differences in society. And all of these ideas led to the shaping of a constitution that is quite visionary. So just because it was not by direct elections, which the logistics in a country with that many people at a time when there was partition and barely any literacy, would have been quite impractical. So you'll see that the document that came out is actually quite visionary, and it was making the best of a given scenario in terms of how these representative bodies were involved. And even though it was only indirect elections, you'll see that a lot of these documents did go out for consultation with people, with various groups. So you'll see different religious groups. So, or like depressed classes or Jains or Muslims. You'll have representatives of these communities who will take part in discussions about how equality should play out. So even though it was just a certain number of people, you'll see that this was actually a conversation with the nation. Thank you.
Thank you so much. I think we're running out of time, so we have time for one last question. Maybe Aniruddha, you would like to take this. What, in your opinion, would be the landmark event or the biggest achievement in the evolution of our constitution?
I think there's no doubt in anybody's mind. It's the Keshavananda Bharati, and which comes from the from Professor Conrad's ideas. Although in A.K. Gopalan, they often refer to him as the great Nambiar, who was the counsel and the father of the current Attorney General. So Nambiar argued the point of basic structure, not in the precise language as we understand today, but he was referring to certain ideas. And if you read A.K. Gopalan, the first case of the powers of the parliament, we do find some early references to some sounding of there could be something which one might eventually call the grand norm, the basic norms, the basic structure. And then, of course, Keshavananda Bharati is the watershed moment, because it gives clarity that you may be the parliament, but you're not the end in itself. And even cases like I.R. Coelho build on it. They're not they're building on it. So what we can say is, if the constitution moment was the making of the Indian constitution, the second prominent moment, or the first prominent moment in the life of the constitution, because after it took birth, the first prominent moment was this idea of basic structure, which just transformed the way in which we look at the constitution now, not just in relation to the relationship between parliament and fundamental rights or the right to amend, but generally. And then Minerva Mills is again building on it. What are the elements of basic structure? So what has evolved thereafter is basically building on that, one might say, superstructure on the structure of the constitution. So I think there ought not to be doubt in anybody's mind about that's the pivotal moment. But the most difficult question is, how well is this test going to stand, which with the tests that the time is going to pose to the constitution? And as Mr. Bhatia very rightly said, it's an evolving document, which was also Professor Fisher's and Ms. Surana's point, is how well it can evolve with that balance, and it can stand the test of time.
Thank you so much. I think I would like to thank all the speakers. Thank you all for sparing your time today. I think we can all safely conclude that despite all the differences between our two countries and our founding moments, both the constitutions have been able to draw on the template of liberal constitutionalism, and we've been able to create lasting and vibrant democracies, which not just survived but also thrived in the years to follow. So thank you all, and happy Constitution
Actually,
Day.
sorry, Keshavananda actually is the moment in time when the Weimar Constitution failed. So it's a similar, very different also, but also a similar political scenario of emergency power and everything. When Weimar collapses, India goes through it. And so I would definitely agree. And it was actually already the teachers of Dieter Conrad, Anschütz, and Schmidt, and then Forsthoff was Schmidt's PhD students, and Conrad is Anschütz, Forsthoff's PhD student. This is long trouble, but take it back to the Weimar Constitution, and you will see a specific political setup that makes that constitution collapse. And the takeover of the Nazis whereas India comes out of this crisis stronger with redesigned emergency provisions. So I just wanted to add this. Sorry for taking up so much time.
Yeah. Thank you so much. Thank you all once again. Bye.